Our next talk is going to be by Aliyah Akram and Olinga Tahzib, who are both members of Outer Temple Chambers. Aliyah has a very successful practice involving significant amounts of group litigation. She's ranked in the directories for personal injury, international personal injury and industrial disease litigation. And Chambers and Partners quotes her as being star of the future and is very detailed and prepared. And I can certainly endorse that. And Olinga, he keeps the cerebral theme going. He came to the law after gaining a double first at Oxford in physics and philosophy, followed by a master's in the philosophy of physics. So he really knows his stuff. He practices in personal injury, clinical negligence, and employment law. And they're going to talk to us about parent company liability in asbestos cases. So, Aliyah and Olinga.
Okay, so the first question to be addressed is why are we talking to you about asbestos litigation at all? And I think one of the points that some of the English lawyers in the room might notice that normally in our jurisdiction, asbestos claims are brought as employers' liability claims. And there's lots of reasons for that, including the fact that we have a very well-established system of employers' liability insurance and a great deal of employers' liability legislation. So that would be the vast majority of asbestos litigation. But I know that, firstly, that's very different to other jurisdictions, and particularly in the US, product liability litigation and asbestos is intimately tied together, and the same in Australia, and I think that might be true of other jurisdictions. So, firstly, a point of interest, and it may be that later down the line we have a bit of a conversation about that. But what's our justification for talking to you about asbestos litigation now? The first point is we do bring asbestos product liability claims in England and Wales. Members of Chambers are instructed in claims involving CAPE, which we're going to end up talking about a lot because they were one of the biggest asbestos manufacturers in the UK in the 20th century. Also, it's a bit of a hot topic at the moment because there is a lot of conversation about, following on from the US litigation, about talc and Johnson & Johnson and various other manufacturers and the link between asbestos in talc and mesothelioma, which is a disease which is almost exclusively caused by asbestos exposure, and ovarian cancer. Again, there are some links between asbestos exposure and that disease. So it's interesting from that point of view because I certainly see room for significant growth for this kind of litigation in our jurisdiction. But then the other point is it's interesting because asbestos litigation often gives rise to very nitty-gritty areas of or legal issues, and part of that is because by its very nature it has to be historic litigation. There's at least, for those who don't do lots of asbestos work, there's at least a 10-year lag between asbestos exposure and the first symptoms of mesothelioma. So inherently they're historic, but often we're talking about decades after the event, so that changes the nature of the claim to some degree. But because of that, you end up with legal issues which have ended up being very relevant to other parts of litigation, including product liability. One of the other points I'd say is that obviously we're not talking about, or the historic natures of claims aren't relevant when you're bringing CPA claims, you've got the 10-year long stop, but the or bringing a tortious claim under the common law is, again, something I think is interesting in the product liability sphere and something that asbestos has a lot to say about. So that was the intro, the sort of self-justification. Olinga's going to start by giving us a bit of an intro to parent company liability, which started off in the asbestos field, and as he's going to explain, has much broader relevance. And then I'll come back and talk about a few other points.
Thanks, Aliyah. Hi, everyone. So I think one of the sort of most fundamental and sort of common challenges with historic claims is obviously finding anyone with any money left to sue, and where in a situation where the tortfeasor no longer exists, obviously there's basically two routes open to claimants. Depending on the type of claim, there may be an insurer in the picture, but often the only sort of option left is to pursue the parent company. I'm not planning to say very much about pursuing insurers, but I just want to say if there is an insurer, that often is the most straightforward route to liability, to sort of establishing liability. There are reasons why it may not be possible to pursue an insurer. Most obviously if there's no insurance in place, or if there is a policy in place, but the policy excludes the particular illness that the claimant is suffering from. And you may also be in the situation where the insurer itself is defunct. If there is an insurer, and this is really just by way of sort of brief reminder really of how the law works here in England and Wales, there are basically two regimes in place for pursuing insurers where the insured has become insolvent. And which one applies depends on two dates. It depends on when the insured's liability was incurred and when the insured became insolvent. And if both of those events took place before the 1st of August 2016, then it's the 1930 regime that applies. Otherwise, it's the 2010 regime. And the key difference between the two is that under the 1930 regime, where the insured is a defunct body that's been sort of struck off the register of companies, the claimant first has to initiate proceedings to put the body sort of back on the register of companies before you're able to sue it. Whereas under the 2010 Act, things are much more straightforward and you can pursue the insurer directly. So that's really all I wanted to say on insurance. I think the more interesting issue is what you do when there is no insurer available to sue and you have to pursue the parent company. And really the basic position has, I think, been sort of summarized most clearly by Lord Justice Sales in the case of Unilever, which I've cited at the top there. And he says, there's no special doctrine in the law of tort of legal responsibility on the part of a parent company in relation to the activities of its subsidiary vis-à-vis persons affected by those activities. Parent and subsidiary are separate legal persons, each with responsibility for their own separate activities. A parent company will only be found to be subject to a duty of care in relation to an activity of its subsidiary if ordinary general principles of the law of tort regarding the imposition of a duty of care on the part of the parent in favour of a claimant are satisfied in the particular case. So in essence, there's no special test. It's the ordinary familiar tort law principles that apply. And it is sort of now well established that in an appropriate case, the parent company can be pursued on orthodox tort law principles. And really the paradigm case in this area is the case of Chandler, which, as Aliyah mentioned, is an asbestos case. And I have to say, I feel somewhat sort of embarrassed to be the one speaking about the case today, given that we have Sarah Moore of Lee Day who's speaking next. And this was a case in which Lee Day acted for the successful respondent. But in Chandler, Mr. Chandler himself was employed by a subsidiary of Cape PLC. The parent company was Cape PLC. He was employed by Cape Building Products, which was a subsidiary. And he worked as a brick loader in the late 50s and early 60s. And in the course of his work, he was exposed to asbestos dust, which had migrated into his workspace. He then contracted asbestosis about 50 years later, by which time the subsidiary, Cape Building Products, was no longer in existence. And although Cape Building Products had employers' liability insurance, the insurance excluded, it had an exception covering asbestosis. So the only viable defendant in that case was the parent company, Cape PLC. Mr. Chandler brought the case directly against Cape and argued that Cape PLC, as the parent company, owed him a direct duty of care. Now, the parent company, Cape PLC, accepted in that case that the subsidiary had failed in its duty of care, but denied that it owed Mr. Chandler a direct duty. And at first instance, Mr. Chandler was successful, and the first instance judge, Mr. Justice Wynne Williams, accepted the claimant's argument that Cape PLC owed its own duty to him on the basis of the common law concept of assumption of responsibility. The defendant appealed in that case, and it went up to the Court of Appeal. And the Court of Appeal upheld the decision. And the case was really decided both at first instance and on appeal by going back to sort of first principles, really, in relation to duty of care and applying the Caparo test with its familiar 3 limbs. And in the Court of Appeal, the court examined pretty carefully the relationship between Cape Products and Cape PLC. And there were a number of sort of relevant findings that were relevant to the court's conclusion that Cape PLC owed a direct duty. So the key one really was about the level of control. The court found that Cape PLC exercised the level of control over the business carried out by Cape Products. So, for example, the products which were manufactured by Cape Products were manufactured according to a product specification that was determined by Cape PLC. Product development was also carried out centrally. So Cape PLC had a central laboratory and it employed a group chief chemist. Cape PLC had superior knowledge about the asbestos business. Cape PLC had been sort of in the industry since the 19th century. It had several factories across the UK. Its resources far exceeded the resources of Cape Products. And one sort of important finding in that particular case related to the role of a Dr. Smither, who was the parent group's medical advisor. And the court found that he had been responsible for the health and safety of employees across the whole group. And both on appeal and at first instance, the courts were referred to correspondence involving Dr. Smither, where he had sort of involved himself in very specific questions about whether, for example, a particular employee who had contracted asbestosis employed by Cape Products could continue to work, notwithstanding his illness. So he had involved himself in those sorts of questions. Putting it all together, Lady Justice Arden concluded that a duty did arise, and this is how she defined the scope of the duty, the bold text there. So Cape PLC did have a duty either to advise Cape Products on what steps it had to take in the light of knowledge then available to provide those employees with a safe system of work, or to ensure that those steps were taken. And quite helpfully, towards the end of her judgment, Lady Justice Arden set out 4 factors which, when present, will tend to indicate that a direct duty may arise on the part of a parent. So the first being that the businesses are in relevant aspects the same, the fact that the parent has or ought to have superior knowledge, the subsidiary system of work is unsafe as the parent company knew or ought to have known, and the parent knew or ought to have foreseen that the subsidiary or its employees would rely on using that superior knowledge for the employee's protection. So CAPE is really the paradigm case on parent company liability. But the law has sort of evolved in the years since CAPE. And I just want to very briefly mention the case of Vedanta, which is a Supreme Court case. Judgment was given in April 2019. And in fact, it's another Lead A case. Lead A were acting for the successful respondent in this case. The litigation in Vedanta arose out of alleged discharges of toxins from a copper mine into watercourses in rural Zambia. And the claimants in that case were a group of about 2,000 Zambian citizens who were living in a particular district, in the Chingola district in Zambia. There were 2 companies in the frame. Konkola was the owner and operator of the mine, and that was a company that was incorporated in Zambia. And then you have Vedanta, which was the parent company, which was incorporated in the UK. Claims were brought against both of them in negligence and in breach of statutory duty. And the claim against Konkola obviously was on the basis that it owned and operated the mine. And as against Vedanta, the argument was that Vedanta owed direct duties to the claimants by virtue of the sort of high level of control that it exercised over Konkola. And the case went all the way up to the Supreme Court. The appeal really was actually about jurisdiction. It was about the jurisdiction of the courts of England and Wales to determine that dispute. And just by way of a side note, I think this is a judgment that will make for interesting reading for those of you who enjoy reading exasperated Supreme Court judges, because in this case, the court didn't sort of hide its disapproval of the fact that these two companies, both with very deep pockets, had challenged jurisdiction, not only at first instance, but on appeal in the Court of Appeal and then up in the Supreme Court as well. But without getting into the jurisdictional issues, one of the hurdles that the claimants had to overcome was that there was a real issue to be tried against Vedanta. And Vedanta argued in that case that there was no real issue, there was no basis for a claim against it. Firstly, on the basis that it hadn't intervened sufficiently in the management of the mine for a direct duty to arise. And second, that if the court was to conclude that a direct duty did arise, that would be a novel and controversial extension of the law of negligence. The Supreme Court disagreed with that, and Lord Briggs's judgment on the issue is sort of well worth reading. But in summary, he endorsed that summary that we looked at earlier on from Lord Justice Sales, and clarified that parent company liability in these sorts of circumstances isn't novel, and reference was made to the case of Chandler and Cape. The court also clarified that those four factors that we looked at in Chandler, are not necessary features of a case where parent company liability is found. They're nothing more than examples. In the Court of Appeal, so when this case was in the Court of Appeal, Lord Justice Sales had tried to define two basic categories of cases where parent company liability might arise. He had said one category are those cases where the parent, in substance, has taken over the management of its subsidiary and is running the subsidiary in place of or jointly with the management of the subsidiary itself. And the second type of case is where the parent company has given advice to the subsidiary about how it ought to manage a particular risk. But in the Supreme Court, Lord Briggs preferred not to look at it in that way. He says, for my part, I would be reluctant to seek to shoehorn all cases of the parent's liability into specific categories of that kind, helpful though they will no doubt often be for the purposes of analysis. So Lord Briggs pointed out that in reality, there's no limit to the number of ways in which a multinational group of companies can structure itself. So on one extreme, you may have a parent who is nothing more than a sort of passive investor in its subsidiaries. And at the other extreme, you might have a group of companies where they've been sort of vertically reorganized so that they are run as if they were a single undertaking, and you have everything in between. And each of the cases is going to be highly sort of fact-specific. On the facts of Vedanta itself, the Supreme Court accepted that it was arguable that a direct duty did arise, and they looked carefully at some of the published materials of Vedanta, where Vedanta had sort of asserted its own responsibility over the subsidiary. And the final slide from me, I think really just to say that I think this is a fast-developing area of law. Within just 1 year of Vedanta, there was another case that reached the Supreme Court, case of Okpabi, which is another Lead case. So the observant amongst you may detect a theme here. But that was litigation involving about 40,000 Nigerian citizens who were affected by pollution that had been caused by oil spills. I'm not going to discuss it now, but it's another case that applied and sort of illustrated the guidance in Vedanta. So it's an area where I think we're seeing, and we will see, much more litigation in the coming years. I think the challenge with all of these cases, from the perspective of the company, is that there's no bright line test. There's no clear test that tells you whether the parent is going to be liable or not. It's highly fact sensitive. And I think the boundaries of the principles are going to be tested in the coming years. Back to you, Aliyah.
So I agree, Olinga. I think And you could definitely see it in a product liability context with multinational companies, various different companies being set up in different jurisdictions according to commercial demands. But then that leads to the problem of where is the pocket when that product then goes wrong? Where is the decision-making taking place? And that's why I think it's quite interesting to think about these different duties of care and it's not always just the obvious person who's in front of you. What I want to move on to fairly briefly before you're rejuvenated for the coffee break is just to think a bit about evidence. And why I think it's interesting is it's a particular challenge in asbestos cases because unlike our Tesla crashes, there is no data. And so you have to think a bit more creatively about how you're going to prove your claim. There is sometimes some leniency by the court who recognise the position that you are in as a claimant, but you still have to fundamentally prove that what you are saying occurred. So one of the biggest problems is you might not have any witnesses left able to give evidence, or that they might be very elderly. One of the interesting parts about asbestos litigation is in our jurisdiction, it's actually one of the few areas where we do depositions. Not commonly, but we record evidence in advance from particularly from unwell claimants so that it might be available for a trial. And given the length of delays that now really are routine with getting to trial, it's a valuable tool in asbestos litigation. One of the other points that I think, because we've got this slightly transnational theme today to think about, and again, this might surprise American lawyers, is we are obviously very restricted from one set of proceedings to another in being able to use both disclosure and witness statements. So there are various rules of our civil procedure. Firstly, with witness statements, you're only able to use them if you have the consent of the witness or the consent of the court. Obviously, our problem with those cases is often the witness is no longer around, so you have to go to the court, but that's just something that we need to be aware of. And if you're doing this kind of litigation, sometimes people do things like have preemptive consent from a witness. So when they give the statement at the same time, they say, I would be happy for this to be used in other proceedings. And so far that has worked. But one of the points with disclosure is particularly interesting because it means that if you sue the kind of historical company and they end up paying you lots of money and they think, I don't really fancy doing that again, they're no longer within the kind of bounds of litigation so that they have to preserve that evidence. What is to stop them saying, actually, I don't think we want that evidence around anymore, let's just get rid of that? One of the answers is that there's actually a ton of discovery in the US, and so it's literally a treasure trove for us English lawyers from all the US litigation where this doesn't apply as a restriction. But what I thought I might touch on, because it's of interest, is one of the other ways of getting around that problem of what happens if you're worried that this evidence, which is all historical, often it's paper-based, right, because it's from the 20th century, early 20th century sometimes, how do you preserve it? That ended up in a case called Dring, which I just wanted to go through quite briefly. So this is the CPR rule, which essentially says that if you disclose documents in one set of proceedings, you can't just then say, oh, look, I've got this smoking gun, what does everyone else think about this? It leads to a bizarre situation for lawyers, because if you've seen it in one case, theoretically, you're not supposed to know it in the other case, which is sort of bonkers. What happened in Dring was, it's a case from, it has an interesting history, and I'll just touch upon it to explain the context. Back in 2017, there was a 6-week trial, everyone's got silks, in front of a High Court judge, where Cape comes up yet again. Cape were the defendant. But the claimants in those cases, and this litigation is known as Concept 70, the claimants were the insurers who had indemnified the employers of people who had used Asbestolux, a product manufactured by Cape. So the original claimants were just usually working men, carpenters and the like, who'd worked with Asbestolux and developed mainly mesothelioma. They'd brought claims against their employers, and these insurers had paid out on them. And what they now wanted to do was seek a contribution on those payouts from the manufacturer of the product. So it's a clever idea on the part of the insurers. Now, that full trial happens. There are bundles and bundles, and this is, proper paper days as well. There are literal bundles of documentation, and because of the nature of the litigation, it's this big commercial case, subsidiaries and so on get involved. There's tons of disclosure, and Cape do a really thorough commercial disclosure exercise, or the most thorough that we've ever seen them do. The claim then settles between trial and judgment. And because it's insurers as the claimants, well, there's confidentiality throughout, and the sort of wider impact of that litigation is not part of the concern of the insurers when they come to the settlement. So what then happens is Mr. Dring, on behalf of an asbestos charity, makes an application under CPR 5.4c, so he finds a little one, for records of the court. And off everyone goes, and part of the concern, the concern appears to be that once this settlement happens, the documents are going to disappear. And Mr. Dring and his legal representatives think these are really valuable documents for the wider asbestos litigation. How are we going to get hold of them? Because we'd like to see them too. So they all go off to court, and they end up in front of a master who says, "Good point, I think you should be able to see these documents." And as I understand it, says, "Oh, these boxes, yep, just take them." So they all wander off with the documents. And Kate says, "Wait, what?" So they turn up at the Court of Appeal. And the Court of Appeal says, no, you can't just take everything. And in these cases, and there are quite significant implications, not just beyond this case, for a lot of companies and a lot of defendants who suddenly feel slightly uncomfortable at the prospect that if any litigation arises, basically, the doors are open to their confidential documents. So it goes to the Court of Appeal, who greatly limit what they say the claimant is actually entitled to, or the Dring, so Mr. Dring is acting on behalf of the Asbestos Forum, so what they say Mr. Dring on the Asbestos Forum can access. And it ends up in front of the Supreme Court, and I think it must be one of the last judgments from Baroness Hale, and it's a really interesting discussion of open justice. And I think, again, when we're talking about group litigation, things like open justice are really important because there is that wider public concern about litigation. It's not one individual who is injured, it's why has this happened and why have so many people been affected, which again, part of the asbestos context. Lady Hale in the end concluded that parties were entitled to seek access, so non-parties are entitled to seek access to documents relied on in court if they could outline a good reason why this would advance the open justice principle. And so I think it's just something to think about. If you look at litigation that's happening, if you see something that feels kind of relevant, you can kind of think of like a defamation proceedings that is about a product that maybe your client actually knows something about, and we know that that kind of thing happens. There might be a reason, and you might be able to fashion an argument as to why some of those documents should be disclosed to you now, and there are good reasons that you might want to do that outside of your own litigation context. In the end, in Dring, it went back and forth and went back down to the High Court judge to decide what should actually be publicly available, and what is publicly available now are the statements of case, the witness statements, the expert reports, and the written submissions, which is actually a huge amount of information, which gives you a good idea of what the evidence is, and it's all available at that link if anyone is interested in having a delve. It's interesting. Just the last thing I'm going to touch upon very briefly, and it's just, I suppose it's just, again, something I find interesting, and I just wanted to raise as something to maybe discuss again in the future. It's a point that was raised by Olinga when we were looking at Chandler and Cape about Cape having that superior knowledge because they are the manufacturer, and that's got to be true in so many product liability claims. You are developing this product. It is not about the wider public being able to assess its safety. You have much better knowledge. But then the other, I think, particularly interesting thing in the asbestos industry, and in particular with Cape, and this was one of the allegations made in Concept 70, is the claimants alleged that Cape didn't just have superior knowledge, they controlled what knowledge became. Firstly, they controlled the research. So these were asbestos bodies in which they were intimately involved. They founded them, they helped to direct their research. And then they were involved in how that information was then disseminated to the wider public. So it's not even just about being in a position of superior knowledge, it's then about manipulating what knowledge is known by the public. And that, I think, has obvious parallels with the tobacco industry. And, it's not the only industry that has attempted to do that. But again, an interesting point from asbestos litigation that I think has wider implications. And that's it from us, I think.
Well, thank you very much, Aliyah and Olinga. I think a very snappy and accessible discussion of a topic that can be pretty inaccessible and dense. So thank you.